Issues raised by Hedley Byrne Co Ltd. A negligent misstatement may give rise to an action for damages for economic loss. When a party seeking information or advice from another, possessing a special skill, entrusts him to exercise due care, and that party knew or ought to have known that the first party was relying on his skill and judgment, then a duty of care will be implied. Hedley Byrne were advertising agents placing contracts on behalf of a client on credit terms. Hedley Byrne would be personally liable should the client default. To protect themselves, Hedley Byrne asked their bankers to obtain a credit reference from Heller Partners Ltd, the client's bankers. The reference, given both orally and then in writing, was given gratis and was favorable, but also contained an exclusion clause to the effect that the information was given, without responsibility on the part of this bank or its officials. Hedley Byrne relied upon this reference and subsequently suffered financial loss when the client went into liquidation. Hedley Byrne were advertising agents placing contracts on behalf of a client on credit terms. Hedley Byrne would be personally liable should the client default. To protect themselves, Hedley Byrne asked their bankers to obtain a credit reference from Heller Partners Ltd, the client's bankers. The reference, given both orally and then in writing, was given gratis and was favorable, but also contained an exclusion clause to the effect that the information was given, without responsibility on the part of this bank or its officials. Hedley Byrne relied upon this reference and subsequently suffered financial loss when the client went into liquidation. The court found that H&P's disclaimer was sufficient to protect them from liability and Hedley Byrne's claim failed. However, the House of Lords ruled that damage for pure economic loss could arise in situations where the following four conditions were met. A fiduciary relationship of trust and confidence exists between the parties. B. The party preparing the advice information has voluntarily assumed the risk. C. There has been reliance on the advice info by the other party, and D. Such reliance was reasonable in the circumstances. In the years following Hedley Byrne, other types of economic loss claim were tried and sometimes successful. Defective products, including construction projects, were held to result in liability, culminating in Annes v Merton London Borough Council, where the court held that the negligent oversight by a council resulting in cracks to a building from inadequate foundations amounted to material physical harm, rather than pure economic loss, so that damages for the costs of repairs were recoverable. This case was followed 5 years later before a major shift in the legal climate resulted in this decision being overruled. The House of Lords in Caparo Industries plc versus Dickman also refined the Hedley Byrne test. Lord Bridge set out the 3 requirements to be found before a relationship of sufficient proximity would be established in a misstatements case. In Caparo itself, reliance on the information was not reasonable because it was supplied for one purpose and could and should not be relied upon for any other purpose. The current test for determining assumption of responsibility was set out in Henderson v Merit Syndicates Limited. Investors, acting in syndicates, in the Lloyd's of London insurance market, the names, brought claims arising out of losses incurred in the 1980s. The actions were against underwriting and managing agents who had set out the syndication for negligence. The House of Lords unanimously ruled that liability may be found even where there is no statement or advice relied upon, if there has been an assumption of responsibility for the conduct of another's affairs. Lord Gough, giving the lead judgment, specifically built upon his decisions in earlier cases, emphasizing the concept of assumption of responsibility and stating that even in Hedley Byrne itself, Lord Devlin and Lord Morris's judgments showed that the principle extends beyond the provision of information and advice to include the performance of other services. This case also dealt with concurrency, the liability in both tort and contract on the same facts. Lord Gough considered that both were possible and that a claimant who could choose between the two was able to select the remedy that was most advantageous.